Hey real estate professionals, welcome to Velocity Title's Title Minute. Today, our very knowledgeable real estate attorney Glenn Donaldson will be discussing the significance of the Statute of Frauds. You better make sure you have everything in writing. After he's done, he'll be sharing an email address where you can send in any questions or comments you might have, and we'll get back to you as soon as we can. Thanks for joining us for Velocity Title's Title Minute. Now here's Glenn.
Thank you, Lauren, and welcome back everybody to the Title Minute by Velocity National Title Company. I'm Glenn Russell Donaldson. I'm an attorney for Velocity Title, and today I want to talk to you about the Statute of Frauds. It's an area of law specifically related to real estate contracts, and a lot of real estate professionals, brokers, lenders really get themselves into a little bit of trouble relating to this issue of the Statute of Frauds. So let me back up just a little bit and talk about real estate contracts. Real estate contracts are unique in the sense that you can't have an oral agreement about any term or any condition relating to a real estate contract. Other contracts, by their very nature, can be established through the creation of an agreement. It doesn't have to be in writing. It just has to be a meeting of the minds between a buyer and a seller of some good or some service. If somebody was painting my fence, let's say, and I agreed to pay them $1,000, we can have that agreement in a completely oral fashion. Shake hands, he gets to work. When he's done, I look at it, I pay him the $1,000. If there's a dispute, we both get to go into court, and we get to tell our side of the story to the judge, and the judge makes a decision as to who's right and who's wrong. Real estate, on the contrary, cannot have any term or agreement in an oral fashion. If it is not written, it's not said. So let me give you an example. We talked about this before in one of our earlier sessions. If you have a date certain in a contract for real estate that provides for settlement to occur on a specified date, and then the parties agree for whatever reason that they're going to amend that date, and for any number of reasons the real estate professionals representing the buyer and the seller get on the phone with each other, they email back and forth with each other, and everybody agrees to extend settlement by 5 days. But, and this is where the real estate professionals find themselves sometimes sitting before the Maryland Real Estate Commission. The parties have agreed in an email, the parties have agreed in phone conversations. Neither one of the two agents memorialized this in a written addendum extending the settlement date. So settlement is just fast approaching on the original date that was specified in the contract, and the buyers find out that they are not able to extend settlement, because if they do, then their loan lock is going to expire. And a lot of you out there already understand where I'm going with this. That lock is going to expire, and if it does, that buyer's loan is going to be subject to whatever the prevailing rates are at that time. The buyer can force the settlement on the original date despite the other contrary emails and oral agreements, because there was no written addendum specifying a change in the date. There can be no testimony even allowable in a court called oral testimony that relates to what the parties agreed to. If it's written and it's signed by the parties, that's it. Don't get yourself in any kind of trouble. Don't get yourself in any kind of hot water. If you have a question, reach out to us at contractquestions@velocitytitle.com, or check out our brand new contracts hotline. You can call us at 1-800-MY-RE-LAW. That's 1-800-MY-RE-LAW or 1-800-697-3529, and we'll be happy to answer any questions. Again, Glenn Russell Donaldson on behalf of Velocity National Title Company. We'll talk to you soon.